All right, well, let's make a start. I'd like to welcome everyone to the second in our series of regular arbitration briefings, which will take place during the course of this year. We hope that you're going to find it instructive. Good morning to our friends and colleagues in the UK, elsewhere in Europe, if I can still say elsewhere after Brexit, and in Africa. Good afternoon to those of you joining from the UAE and Mauritius. Good evening to those in Singapore and elsewhere in the Asia-Pacific region. With me today are my colleagues Stephen Brown and Jaiwei Lee, who form part of the arbitration team at Wilberforce Chambers. And today we're going to be discussing some current issues relating to the conduct of multi-party arbitrations, the joinder of non-parties to an arbitration agreement, and disputes under multiple contracts. There are many such issues, but we've selected those that we hope will be of greatest interest and topicality and focused on conflict of law issues. The discussion today is going to focus on 5 main topics. First of all, the recently introduced provisions in the rules of the main arbitral institutions and in Singapore legislation concerning multi-party arbitrations and disputes under multiple contracts. Second, the UK Supreme Court's decision in Enker and Chubb on the choice of law governing an arbitration agreement and the approach that's taken in other jurisdictions. Third, some conflict of law questions relating to the law which governs the question whether a party is properly joined into arbitration proceedings. And fourth, some particular questions surrounding the joinder of parent and subsidiary companies. And finally, and assuming time permits, methods of challenge to joinder questions. As always, we're very keen that there should be an exchange of views. We welcome your contributions. And please use the Q&A button at the bottom of your screens rather than the chat button to ask questions throughout the session. We're very happy to try to deal with questions as we go along, so feel free not to wait until the end of the discussion if you want to raise any questions. Finally, for amusement, as always, we have a few polls during the course of the discussion from which we are interested to get your own instinctive or possibly considered views on the questions that are going to be asked. Stephen, over to you.
Thank you, Stuart. Good morning, everybody. We're going to start by just outlining some of the recent changes to the rules of some of the leading arbitral institutions, so far as they're relevant to what else we have to say today. Now, I'm sure you will all have read them, and some of you on this webinar will have written articles about them, so we're not intending to spend very long on this. Before we look at the rules, I should just define a couple of terms. Where we're speaking of joinder, that means either the joining of a third party to a pending arbitration at the request of an existing party, or intervention by a third party of its own volition. And a third party, as you know, does not mean anyone that might be relevant to the dispute. Arbitration is contractual, and someone is a third party by reference to the pending arbitration, but they still have to be bound by the arbitration agreement. And that arises either if they were a signatory to that agreement, but for some reason were not joined into the arbitration at the beginning, or if they're bound by operation of law or some legal principle, for instance, by assignment, agency, statute, and so on. And we'll come back to this. And I'm going to start now with looking at joinder under the 2020 LCIA rules. As you know, these changed on the 1st of October last year, and Rule 22.1.10, under that rule, the tribunal has the power, let's read from it, to allow one or more third person to be joined in the arbitration as a party, provided any such third person and the applicant party have consented expressly to such joinder in writing following the commencement date, or if earlier, in the arbitration agreement, and thereafter to make a single final award or separate awards, excuse me, in respect to all parties so implicated in the arbitration. Now, the only change from the 2014 rules is the addition of the word expressly, so that the third person and the applicant party have to consent it expressly. There's no requirement for a claim to be made against the third party by the applicant. They could be joined, someone jointly liable. One might contrast that with the ICC Rule 7. Waiver of the right to be involved in the selection of the tribunal is impliedly captured by the rule. Compare that with the LCIA Rules, which expressly state the right is waived, and contrast it with the position in France, which I understand is that it's against public policy for a party to an arbitration agreement to waive the right in advance of the dispute arising. Other changes were made in 2020, as you know, and the main one related to today's topics being the new Rule 22A regarding the power to order consolidation or concurrent conduct of arbitrations. It's also possible under Rule 1.2 to serve a composite request to commence more than one arbitration, provided the requirements of the rule are met. Stuart, did you have a comment on any of that? Or we're straight over to John Way?
No, I think, Stephen, there may be a problem with your volume if you're able to turn it up a bit more.
I've finished now. I think Jai Wei is speaking next about the rules of the ICC.
Yes. Well, I'm going to talk about the ICC rules from 2021, which came to force at the beginning of this year. And they create additional flexibility for complex arbitrations in two ways. First, there is now extra scope for consolidating claims. The old Article 10 under the 2017 ICC rules provided for consolidation only when all parties consented or the arbitrations fell under the same single arbitration agreement, or they fell under compatible agreements with the same parties in connection with the same legal relationships. The new Article 10b has expanded consolidation to claims made under the same arbitration agreements or arbitration agreements in the plural. And the practical addition that this creates is that consolidation can now take place between different parties who have the same arbitration agreement, albeit under different contractual arrangements. And this is very useful in, say, the construction sector, where there will be multiple parties, multiple subcontract arrangements, but which all form part of the same wider development. The ambiguity that arises is not entirely clear what is required under the rules for arbitrations agreement to be considered the same. We think that the ambiguity is probably by design to encourage and build in flexibility to the rules. And we expect that if the central elements to the agreement, such as seat, language, or governing law are different, then probably Article 10b is not engaged. But it's not clear right now whether anything more than that is required. The second change introduced in the 2021 ICC rules is a new provision that additional parties can be joined even after confirmation of the arbitral tribunal in expanded situations. The old rules would only allow joinder of new parties if all parties consented after the arbitral tribunal was confirmed. But a new Article 7.5 added to the 2021 rules now allows for a request for joinder to be made after confirmation or appointment, and the tribunal can consider this request, number one, if the additional party consents to the composition of the tribunal and its terms of reference, and if it takes into account relevant circumstances, which include its prima facie jurisdiction over the additional party. The practical significance of all this is that claimants and respondents can now freely join willing co-parties, irrespective of what any other party to the arbitration thinks. It's quite a useful tool, but there are two short caveats here. The first one is that Article 7.5 expressly provides that the power to join new parties on the part of the tribunal is without prejudice to its decision as to jurisdiction. So in practice, the newly joined party will still have to overcome any objections to jurisdiction that other parties may have. Number two, Article 7.5 is, can I say, a moderate erosion of party autonomy. And that provides a possible basis for challenging awards made following non-consensual joinders on grounds, for example, of contravention of party equality and natural justice. But I think this concern shouldn't be overstated. The party whose autonomy is most likely to be affected in these cases is the additional party, and the additional party has to consent to the tribunal's composition in terms of reference. So really the person whose autonomy is most affected has already agreed to that procedure. So this is really less of a concern than we would otherwise think. I think Stuart will now want to talk about the rules in Singapore that have been introduced.
Before I go on to that, I think it's worth making the point that I'm certainly aware of at least one arbitration under the LCIA 2020 rules, where the bulk of a procedural meeting was occupied by the respondent arguing that the request for arbitration failed to meet the requirements of a composite request under Article 1.2. So it certainly shouldn't be thought that these questions are just of academic interest. They've got real practical impact. Well, moving on briefly to the position in Singapore. Singapore, I think, is arguably the world's most pro-arbitration jurisdiction. The current 2016 ICC rules already include in Article 6 and 7 provisions dealing with multiple contracts and the joinder of additional parties, and further revision of the current 2016 rules is in progress. Now, in the meantime, there have been two important amendments to the International Arbitration Act, which governs the conduct of international arbitration seated in Singapore. One of them concerns confidentiality. I'm not going to deal with that today. But the other introduces into the Act a new Section 9B, which provides a default mechanism for the appointment of arbitrators in a multi-party situation. Under the existing legislation as it was, Section 9A, a default mechanism existed only for two-party situations. It provided that each party would appoint one arbitrator and the parties would by agreement appoint the third arbitrator. And where the parties failed to agree on the appointment of the third arbitrator within 30 days, then the appointment would be made by the appointing authority. In practice, those provisions were often considered to be unworkable in multi-party arbitrations. The new Section 9B therefore provides that where there's an arbitration with three or more parties and three arbitrators, and each side, as it were, the claimant's or the respondent's group, is unable to agree amongst itself on the appointment of the arbitrator, the appointing authority must, on the request of any party, appoint all three arbitrators. And those provisions apply whether there's a single claimant or respondent, but two or more parties on the opposing side. So in that way, any semblance of unfairness resulting from one group having its arbitrator on the tribunal and the other is avoided. As in the case of a two-party situation under Section 9A, where each side has managed to appoint an arbitrator and the two arbitrators are unable to agree on the third arbitrator, then the third arbitrator will be appointed by the appointing authority.
So that's our whistle-stop tour of the new rules introduced for joining and consolidating claims. The next topic we want to touch on today is the question of what law governs the arbitration agreement, and specifically the 2020 decision in Enker and Chubb, where the Supreme Court of the United Kingdom endorsed the three-stage Sul America test in deciding what the law of the arbitration agreement is. Namely, one, that there's been an express choice of law, two, whether there's been an implied choice of law, and three, whichever jurisdiction has the closest connection, and those tests are taken in turn. It's the second stage of this test that we want to focus on. The first stage is self-explanatory and the third is fact-sensitive. And we want to look in particular at two presumptions that will apply in determining whether there's been an implied choice of law. The first is the presumption that the law of the main contract is what governs the arbitration agreement. Now, in the Court of Appeal in Enker, Justice Popplewell concluded that the law of the arbitration agreements will follow the law of the seat if the parties have chosen a seat. And his reasoning was twofold. Number one, that the doctrine of separability meant that the arbitration agreement was distinct from the main contract. And so any choice of law from the main contract shouldn't affect the arbitration agreement. Second, the choice of curial law extended to the determination of rights of the parties under the arbitration agreement. And so in that sense, it's clearly more closely connected to the law of the arbitration agreement than the law of the main contract. Now, the Supreme Court disagreed and overruled the Court of Appeal on this issue, and it concluded that where the parties have expressed a choice of law for the main agreement, the governing law of the arbitration agreements will follow unless there are other countervailing factors, strong countervailing factors, I should add. Now, as far as the Supreme Court's findings on the doctrine of separability goes, I think the Supreme Court must be correct that it is irrelevant, because the purpose of the doctrine is primarily to ensure, in fact, almost solely to ensure, that the main contract's invalidity doesn't of itself affect the validity of the arbitration agreement. But as Mr. Justice Morbig, Lord Justice Morbig rather, noted in Sul America itself, separability doesn't insulate the arbitration agreement from the substantive contract for every single purpose. So it's quite a limited doctrine. But when it comes to the Supreme Court's more general conclusion that it should apply a presumption that the law of the main contract is also the law of the arbitration agreement, I have to confess it's not entirely clear to me which one of the Supreme Court of Court of Appeal is correct, because depending on the scenario, there are good reasons to think that either the law of the main contract or the choice of seat should be determinative. On the one hand, it seems natural that where parties express a choice of law in the main contract, they would presumably intend the rest of their entire relationship to be governed by the same system of law. And to say otherwise would lead to the odd conclusion that a sensible, commercially minded party would have made all the effort to specify a choice of law for the entire agreement, but then didn't do so for the arbitration agreement. On the other hand, the notion that the choice of seat is more closely connected can also make commercial sense, because it's inherently unlikely that businessmen would intend to choose two different systems of law to apply to their arbitration package. I mean, to my mind, the fact that these commercial or practical factors incline both ways rather tells us that the job of inferring a choice of law for the arbitration agreement depends on the circumstances. So the whole notion that we have to fix presumptions must be called into question, I think. One doesn't impose presumptions when it comes to, say, implying terms into contracts. So query why there are such presumptions when it comes to choice of law. And it may ultimately just be a matter of commercial certainty and consistency. But no, I think it's open to question whether or not presumptions are required at all, or whether the Court of Appeal or Supreme Court would necessarily correct. I think I'm going to pop a poll question up as well, somewhere in the margins, or it should appear directly on your screen. It might be fun to take a view, take your pulse as to which of the Supreme Court or Court of Appeal you think was correct. I should vote as well, actually. 64-36 Supreme Court and Court of Appeal. Not sure what that says, but I think we've got a second presumption we want to talk about, the validation principle, and Stuart's going to chip in a couple of views of his own here.
Yeah, thank you. Well, another interesting issue that arose in ENCA, albeit obiter, was to what extent the validation principle should apply. But what is the validation principle? The validation principle is that if an international arbitration agreement is substantively valid under any of the laws that may potentially be applicable to it, then its validity will be upheld, even if it is not valid under any of the other potentially applicable choices of law. Now, ordinarily, the validation principle is regarded as a freestanding rule or presumption, but after an extensive review of the relevant authorities, the Supreme Court ultimately concluded that the validation principle is simply one aspect of the second stage of the Sul America inquiry. It's a means of rebutting the presumption that the law of the seat is that of the main contract, the idea being that a party is unlikely to have intended to choose a law which might invalidate. What's curious is that while it saw the validation principle as being an aspect of determining if there was an implied choice of law, the Supreme Court gave no consideration to the issue whether the parties needed to be aware of the fact that a given choice of law would invalidate the agreement. Stephen, over to you.
Thank you. Can I just check, first of all, can someone wave if they can hear me properly now? Because I gather I was a bit quiet. Stuart, can you hear me properly?
Yeah, it's fine.
Okay, thanks very much. So I was just going to take a quick look at the approach taken by the Singapore Court of Appeal in BNA and BNB, where it decided that it was unnecessary to consider the validation principle. Just to recap on the facts, the parties were Chinese and South Korean parties who'd entered into a commercial offtake contract subject to the laws of the People's Republic of China. And they'd agreed to arbitration in Shanghai and the ICC Rules. By the time the dispute arose, the South Korean party had assigned its rights to another Chinese party, so the parties were all in China. Now, the arbitrators, by majority, determined that Singapore was the seat. The appellant argued that it was not. There was nothing to displace the presumption that the law governing the contract also governed the arbitration agreement and that Shanghai was the seat. As such, the arbitration agreement was ineffective because under PRC law at that time, it was not possible to have an arbitration between two Chinese parties in China under the rules of a foreign institution. Now, the respondent argued that this invalidating effect, argued for by the applicant, pointed to the fact that the parties could not have intended Shanghai to be the seat and PRC law to govern the arbitration agreement. The parties had chosen to arbitrate, and it cannot therefore have been their intention that the arbitration agreement would be invalid. The Singapore Court of Appeal limited its decision to the correct seat of the arbitration, and it did so because if, in the event it determined that Shanghai was the correct seat and that consequently PRC law governed the arbitration agreement, then it would be a matter for PRC courts to determine the validity of the arbitration agreement. And the Court of Appeal stated that the essential point it wanted to make was that, and I'm just again reading from the decision, the party's manifest intention to arbitrate is not to be given effect at all costs. The parties did not only choose to arbitrate, they chose to arbitrate in certain ways, in a certain place, under the administration of a certain arbitral institution. Those all have to be given effect to by a process of construction, which critically gives the words of the arbitration agreement their natural meaning, unless there are sufficient indicia to displace that reading. If the result of this process of construction is that the arbitration agreement is unworkable, then the parties must live with the consequences of their decision. So the Court of Appeal concluded that the invalidity of the agreement under PRC law was irrelevant because the parties were not aware of the impact of such a choice of law on the validity of the arbitration agreement. And this approach suggests that the fact an arbitration agreement would be invalidated by a given choice of law is relevant only insofar as it speaks to the party's likely implied choice. And this approach taken by the Singapore Court of Appeal ensures that party autonomy and consent remains the touchstone, and courts need only focus on what the parties did or would have intended. Over now again to Stuart, I think.
Yes, before we do, there's been one question that's come in on the chat. I wonder if Ji Wei would like to have a go at answering that one.
I can't actually see a question on the chat.
Sorry, it's on the Q&A.
I see it now. Do you think the majority of the Supreme Court in Enker and Chubb were right to extend the scope of the validation principle to questions of scope of the arbitration clause as well as its validity? Well, as far as I understand the Supreme Court's decision in Enker, their application of the validation principle was broadly to treat it as an aspect of, or rather broadly to treat it as a tool for deciding what it is the parties intended and what it is that the parties would have wanted. The approach certainly the majority took there wasn't so much to decide that the validation principle on its own was a sort of freestanding principle. So the idea there is, I think, the reason why the Supreme Court extended its question to issues of scope and validity was really, it saw it as an indication of what the parties would have wanted. And questions of party intention are therefore essential to both scope and validity. But I don't think we can take the validation principle in English law beyond that. It doesn't stand freely as a way to invalidate or limit and restrict the scope of the arbitration clause separately and independently from party choices and party intentions. that's sort of how I've seen the Supreme Court's approach to the validation principle. Can't remember off the top of my head where the paragraph number where they say that is, but I think that's a fairly orthodox application of the validation principle. It certainly doesn't stand alone. Stuart, you're on mute, I think.
Sorry, forgive me. I said that G-way would be my view as well. I don't know whether Victoria has a different view. If she has, we can maybe debate it afterwards. But I'd like to move on now to the third of our main topics, which is what law governs whether a party is properly joined into arbitration proceedings. There's going to be a poll coming up, so please listen carefully to the next bit, if you would. The focus of the inquiry here for today's purposes is going to be on the position of the respondent. There are also questions that arise in relation to whether a claimant is properly joined as well, but let's focus on the respondent's position. I want to give an example based on an arbitration that I'm currently involved in concerning a dispute over alleged breaches of a license agreement between the claimant, who's an Indian company, and two respondents. The first respondent is the counterparty to the license agreement. The second respondent is a company within the group to which the first respondent belongs and is not a party to the license agreement. And both respondents are companies incorporated under the laws of New York. The arbitration is a SIAC arbitration seated in Singapore. The governing law of the license agreement is English law. Now, the claimant's arguments in favour of the joinder of the second respondent into the arbitration are, first of all, that the first respondent is the alter ego of the second respondent, which would involve piercing the corporate veil, and second, that the two respondents are part of the same group of companies and are to be regarded as part of the same economic or business unit. G-Way is going to be saying a bit more later about the substantive English law on alter ego and single economic unit. Now, there are three possible candidates in the example that I've given for the law governing the joinder issue. Is it the law of the seat of the arbitration? Or is it the governing law of the contract? Or is it the law of the place of incorporation of the respondent seeking to be joined? So that's our poll. If you can all vote, and then we'll see what the answer is. Well, 59% say Singapore law, 26% English law, and 15% English law, which I find a great comfort in the case that I'm actually involved in, which also coincides with my view. In the example I've given, it probably didn't matter whether it was the law of the seat or the governing law of the contract, on the basis that there's no material difference between Singapore law and English law, but that's obviously not always going to be the case. Now, some writers, including Gary Bourne, have suggested that another possibility is to apply, quotes, international principles or general principles of law. But to my mind, those concepts are far too diffuse to be meaningful in practice. One can write about them academically, but it's very difficult to define what any international principles may be. One common mistake, which it's important to emphasize, is to conflate the law which would determine the liability of the respondent with the law which determines the question of joinder. There are two separate questions. First of all, what law determines whether the arbitration agreement should be extended to a non-party? And if that party is properly joined, what law determines its liability? And there may be some overlap, but they're not coextensive. Suppose that the alter ego argument and the same economic entity argument would be sufficient in the example I've given under New York law to make the second respondent liable for the acts of the first respondent. It doesn't follow that the second respondent is properly joined into the arbitration proceedings if those arguments are not valid as a ground for extending the arbitration agreement under the law of the seat or the governing law. In the case in point, first of all, veil piercing is always an exceptional manoeuvre. Second, courts and tribunals have adopted generally a restrictive approach to its use, certainly in common law jurisdictions. Third, the burden rests on the party attempting to subject a non-signatory to the arbitration agreement to demonstrate that the non-signatory is bound by it. Fourth, the principle of the severability of arbitration agreements, which applies in England and Singapore, implies that even if a non-signatory is considered bound by the arbitration agreement, it's not necessarily bound by the underlying contract and may not be liable for the signatory's obligations. So I would therefore advance a strong case for saying that the applicable law should be either the law of the seat of the arbitration or else the governing law of the contract. And from the poll, I think most of you agree with that approach. And as I said in the example that I've just given, it doesn't matter because there's no material distinction between Singapore and English law, but in other cases it may matter. In the end, I would suggest that the matter is well summarized by Professor Hanotiao in his excellent work on complex arbitrations, which has just come out in its second edition. He writes, quotes, "The issue of who is a party to the arbitration clause is mainly viewed as an issue of consent, but extension may nevertheless be achieved by recourse to such other theories as agency, trust, or piercing the corporate veil. The determination is fact-specific." And that's a very concise, neat summary of what I think the position is.
It's a neat way, I think, of transitioning to the very specific question of how and whether parent and subsidiary companies can be joined. Stuart's already mentioned that there are a number of fact-specific legal mechanisms, if we can put it that way, for seeking to join non-parties. In the context of parent and subsidiaries, there are a number that I think we can walk through in this talk. The first is, under English law at any rate, the Contracts, Rights of Third Parties Act 1999. That act allows a third party to enforce a contractual term in circumstances where the contract and the contractual term in question expressly provides that the third party may do so, or quote unquote purports to confer a benefit on that third party. Section 8 of the 99 Act specifically provides that if the arbitration clause falls within the scope of the 99 Act, then the third party is to be regarded as a party to the arbitration agreement. It can bring a claim under it and is also bound by that agreement. So for all intents and purposes, if the arbitration clause is such as to confer a benefit on this third party, the third party effectively becomes a viable party to the arbitration agreement. However, the mechanism itself is limited in two key ways. First, it's actually quite narrow in scope. It's necessary, pursuant to section 1, subsection 3, for the third party to be expressly identified in the contract itself, either by name or as an identifiable member of a class. So even where the arbitration clause does in fact in practice confer a benefit on the third party, it's not often that arbitration agreements will be able to identify that third party. Second, the third party itself cannot rely on the arbitration clause to stay proceedings under Section 9 of the Arbitration Act 1996. So these two limitations mean that in fact, the Rights of Third Parties Act 99 isn't quite as useful a mechanism for joining third parties under English law as one might have hoped, in particular parent and subsidiary companies. Secondly, there is the doctrine of agency, which provides to the effect that if a subsidiary contracts on behalf of a parent company, then of course the parent company will be bound by it and presumably can be joined therefore to any arbitration as a party. But agency will only work if the parent has either specifically authorized the subsidiary to contract on its behalf, or has created an impression to the counterparty to the arbitration agreement that the subsidiary was indeed its agent, so that some sort of ostensible authority can arise. That is not often going to be the case, and as such, agency is also relatively limited doctrine in this context. Thirdly, subsidiary companies and parent companies can assign rights under arbitration agreements to each other. Indeed, Section 82, subsection 2 of the 1996 Arbitration Act defines a party as including any person, quote, claiming under or through a party to the agreement, to provide precisely for such a scenario. But this is obviously going to be of limited assistance to claimants who are trying to seek to join parents or subsidiaries as respondents. Number 4, the parties may invite the court to pierce the corporate veil, as Stuart has already alluded to. But as he's also alluded to, in English law, this is only permitted in very, very narrow circumstances. And in Preston Petrodel, which was a 2013 Supreme Court decision, it found that the corporate veil would only be pierced where a person was under an existing legal obligation or liability, subject to an existing legal restriction, which it deliberately evaded or whose enforcement it has deliberately frustrated by interposing a company under its control. This fact pattern is quite narrow and is not usually going to be the case when it comes to parent companies and subsidiary companies in arbitration situations. Because typically where a party is looking to join their parent company, their subsidiary company, or indeed any group affiliated company, that's because one party or the other is insolvent, or the victim of the damage is not actually a party to the arbitration agreement, but actually some other party in the group. So really, it's fairly rare that the corporate veil itself will be pierced, meaning that this doctrine is, again, of relatively limited assistance, at least as a matter of English law. Number 5, the parties may try to rely on what is widely referred to as the group of companies doctrine. And put briefly, the group of companies doctrine provides that it is a principle that a contract that's concluded by a company becomes binding on its group of affiliates by reason of there being, so to speak, a single economic reality. But I should note that as a matter of English law, this doctrine has been twice rejected by the High Court and Court of Appeal, first in Peterson Farms in 2004, and then in London in Sanchetti in 2008. And there seems to be little appetite, I think, for the doctrine's wider receipt into English law. One will probably have better luck trying to invoke this doctrine outside of England and Wales. And indeed, the concept itself is popularly attributed to the Dow Chemical case. In that case, a claim was successfully brought before an ICC tribunal, not only by the companies that had signed the relevant arbitration agreements, but also by the US parent company and a French subsidiary in the same group. When the Paris Court d'Appel was confronted with an application to set aside this award, it then ruled that all 3 companies, the parent company in the USA and the French subsidiary in the same group, all formed part of the same economic reality, and that therefore the French and US companies were parties to the arbitration agreements, even though they hadn't actually physically signed them. For my part, as a bit of an aside, and without wanting to pretend to be an expert in the law of any other jurisdiction, indeed, without wanting to pretend to be an expert in the law of English law, it seems to me that any time the doctrine is utilized, the relevant tribunal or court is usually very, very careful to emphasize that the mere fact that these companies are economically connected is not an independent reason to permit their joinder to an arbitration. Rather, the fact that there are economic connections of this sort are merely proof and evidence of a common intention to be bound by the arbitration agreement. So the touchstone is always, what did the parties intend? A good example, I think, is in a series of Brazilian cases. A number of non-signatory parent companies were joined to arbitrations on the basis that they had actively participated in the formation of contracts of which the arbitration clauses formed part. And the underlying idea, the substratum of this case, is that if the parent was a necessary part, is that the parent would have become a necessary part of the arbitration, of any subsequent dispute, because given how central the parent company was to the underlying contracts, no dispute or no arbitration would make any commercial or practical sense without that parent company. And so by implication, these parent companies had necessarily consented to the underlying arbitration clauses as well. Ultimately, whatever the theoretical basis of the group of companies doctrine, I think what is absolutely crystal clear is that one is probably going to have better luck trying to join non-party parents or subsidiaries when English law is not being applied. And if trying to resist joinder, then you would probably want English law to apply. That's, I think, the takeaway from my brief run through of the various means by which parties can be joined to arbitrations.
Thanks, Jiwei. We've had one question in from an anonymous attendee. The question is, what role does the law of the place of incorporation registration of the contracting party have in determining issues of piercing the corporate veil and or corporate succession? To my mind, the answer would be that the issue would normally fall to be determined by the law of the place of incorporation or registration. So it's a different ballpark from what we were discussing earlier about the law governing the joinder issue. And that's actually just the issue I have in the arbitration I was giving an example of, where under New York law, if as a matter of conflicts of laws of the seat of the arbitration, that is the right system of law to apply, then the law of the place of incorporation would govern the piercing the corporate veil issue. I don't know whether you or Stephen have got any other points on that.
There's actually an English decision from 2015, Eggy Azarian, which deals not squarely with the point, because the piercing of the corporate veil didn't quite make its way into that case. But what happened there was that the respondents had supposedly orchestrated a corporate raid to try to oust the claimant from a hotel development project in Moscow. The contracts themselves were a shareholders' agreement governed by English law, and it contained an arbitration clause. The second respondent was the city of Moscow, which was a public authority, and it wasn't a party to these arbitration agreements, but its subsidiary company was. And what the claimants were trying to say was that a provision of the Russian Civil Code allowed the city of Moscow to be joined because it made a parent company jointly liable, or jointly and severally liable, I think, on the relevant contract as a whole, which included the liability to perform the arbitration agreement. The question, the arbitral tribunal had originally refused jurisdiction, and this was subject to challenge in the English High Court. And what Mr. Justice Burton concluded was that the city of Moscow was properly joined because Article 105 of the Russian Civil Code, which permitted the joinder of the city of Moscow, applied. And in so doing, he said, well, we need to separate the question of the law, rather, we need to separate the law governing who is a party to the arbitration agreement itself, which would presumably be determined by the curial law, and who is entitled to be joined to the arbitration, because the former question is about the arbitration agreement itself. Whereas the latter question, as we've just discussed, is a question of substantive law. It's a question of how we interpret, say, statutory provisions that allow for joinder, or in your question, any sort of common law principles like piercing of the corporate veil that might apply. And those, in Mr. Justice Burton's view, and in fact, in mine and Stuart's view, logically falls to be determined by the place of the incorporation of the company, because they go to the heart of the extent of one party's liability for the actions of a subsidiary. And these are substantive questions that are probably best determined by the law of the place of incorporation rather than the law of the place of the arbitration agreement. So there is some authority which helps to answer your question, I think.
Can I just add one other comment while you've been talking to you, where I've been looking again at Professor Hanatia's new edition, paragraph 225, he says this: the issue of what law governs the theory of piercing the corporate veil doesn't receive a clear or at least unanimous answer. According to Gary Bourne again, various authorities have applied the law of the state of incorporation, which is what I and I think you and maybe Stephen would regard as the orthodox view. But then Gary Bourne has obviously got a bee in his bonnet, because he goes on to say that the weight of authority rejects those analyses, applying international principles or general principles of law. Stephen, over to you. You're on.
Thank you, Stuart. Yes, I just need to unmute. Sorry about that. So the last thing we're going to look at today is challenging joinder, and in the scenario we'll look at an LCIA arbitration seated in England, and we'll look at this briefly from the perspective of a party who's objected to joinder and already lost before the tribunal, and is therefore appealing to the court, applying to the court. And as usual, the options require consideration of the provisions of the Arbitration Act and the LCIA rules. And the usual triumvirate of sections of the Act have to be consulted. Section 67, jurisdiction, Section 68, serious irregularity, and Section 69, appeal on a point of law. And of course, one must bear in mind that Section 73, pursuant to which the rights will be lost if an application is not made forthwith or within a prescribed time frame. Now, Section 69, appeal on a point of law, we might consider that a claim in this respect of a party that's been joined outside the scope of the jurisdiction conferred by the arbitration agreement would fall under Section 69. That's because the scope of the clause is a matter of construction, and construction is a question of law. However, we can discount this promptly because the right of appeal on a point of law is a right which, under the Act, the parties can exclude by agreement, and the LCIA rules so provide. Rules 26.8 says the parties waive irrevocably their right to any form of appeal, review, or recourse to any state court or other legal authority, insofar as such waiver shall not be prohibited under the applicable law. Section 67, which is, as you know, concerned with substantive jurisdiction, in Union Marine and the government of Comoros, it was held that joinder was not a matter of substantive jurisdiction that can be challenged under Section 67. And the reason for that was that substantive jurisdiction is defined by Section 82 of the Act as referring to matters covered by Section 30, 1A to C. And those are the validity of the arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. Instead, in that case, it was held that the award could be challenged under Section 68(2)(b, which, as you know, is serious irregularity. And in the case of C and D1, which is another High Court decision in 2015 of Miss Justice Carr, a new defendant had been joined to an LCIA arbitration in a dispute that involved a number of agreements, and the claimant objected to the joinder, relying on Section 68(2)(b, serious irregularity, and arguing that the parties had agreed that the LCIA's power to join a party was excluded. Now, the defendants argued that joining a party was not a serious irregularity, but at its highest was an error of law, being an erroneous exercise of an actual power. And the judge rejected the defendant's argument, and she reasoned that adding a party to the arbitration is a jurisdictional decision in substance, since it expands the jurisdiction of the tribunal over the parties to be bound as against each other by the tribunal's decision. The judge held that adding a party was a decision that was more than an error of law, and that if the facts were established, would amount to an excess of power. However, she then found that there had been no agreement that the LCIA's power to join a party was excluded, and so there had in fact been serious irregularity.
Thank you, Stephen. I just want to go back to the joinder issue again, if I may, because much to my pleasure, Professor Hanotiao is listening in on this webinar, and he makes this point: the group of companies doctrine is an unnecessary and confusing concept, and it's abandoned even in France, where it's said to have originated. It's nothing else than the application to group of companies of the concept of implied consent the role that the non-signatory has played in the negotiation, performance, or termination of the agreement. So thank you very much, Professor Hanotiar, for that contribution. So that, I think, takes us to the end of the topics we wanted to discuss. If there are any other points that anybody would like to raise, please feel free to do so. We'll give you a moment or two afterwards to raise anything. But subject to that, we hope you've enjoyed today's breakfast briefing. We hope you found it useful. Thank you very much indeed for taking the time to participate. And we very much welcome your thoughts and comments, both as regards what we've been talking about and also any suggestions that you may have for any further briefings. We've got a series of 6 lined up before the summer break. The next one is going to be on the not quite exhausted yet topic of the Supreme Court's case in Halliburton. That's going to be in March, but we hope we're going to put a different angle on that. But subject to any questions, thank you again, and we look forward to seeing you again.